All right, good afternoon, everybody. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores?
Present.
Phil?
Here.
Senator Lang? Senator Nguyen? Senator Hansen? Senator Krasner? Senator Ellison? Chair Scheibel?
And I am here. Thank you. Please mark Senator Nguyen present when she arrives. We have a busy afternoon today. We have 3 bills on for hearing. It's my intention right now to take them out of order, starting with SB 450. And since I am presenting that bill, I will hand the gavel over to my fantastic Vice Chair, Senator Flores.
And with that, we'll open up the hearing on Senate Bill 450. Madam Chair, whenever you're ready.
Thank you so much. I understand that Mr. Hawks is present down in Las Vegas, and I don't see him at the table yet. But I think he heard me, and he is headed up to the front table. So, by way of introduction, my name is Melanie Scheibel. I'm the state senator for District 9 in southwest part of Las Vegas, and I'm happy to be here today to present SB 450. SB 450 relates to the employment of marshals or deputy marshals and bailiffs in counties with populations of 700,000 or more, which, as you all know, I'm sure right now would only be Clark County. Over the last few years, probably 10, 15 years, there's been a growing need to clarify the roles of bailiffs and deputy marshals in Clark County because historically these positions were appointed by judges or justices of the peace and served at their pleasure. In the modern era, they have been selected more like we see other law enforcement officers selected into a general pool of post-certified individuals who are able to provide the safety and security that is needed in a courthouse like the 8th Judicial District has at the Regional Justice Center. In addition, recent legal precedents have highlighted the distinction between state and local government employees, emphasizing that local executive department employees are not part of the state executive department. The distinction is crucial as it impacts how we manage personnel within the judiciary. Nevada Supreme Court has also underscored that the separation of powers doctrine primarily applies to state government, not local government. So this bill seeks to align those roles with modern governance structures, ensuring the judiciary maintains its autonomy. I think the best way to kind of understand what this looks like in practical perspectives is to think about the way that we interact with our legislative assistants here in the Nevada State Legislature. Our legislative assistants generally are not directly hired and fired by us. We don't set their hours, we don't dock them pay, we don't discipline them, and we also don't set the standards for their performance. However, every legislative assistant is, of course, assigned to an elected member of the legislature individually. And there really isn't much question about, who runs the day-to-day operations within their own office. And the legislative assistant works hand in hand with that legislator to provide a service that is necessary for the functioning of the office. It's similar with judges. Every judge has their own bailiff or deputy marshal. In Las Vegas at this point, I think they're all deputy marshals who establishes or who runs the courtroom for them and maintains safety and security in the courtroom. The issue right now is that there's a blurred line between who is actually the employer of that deputy marshal, whether they are employed by the individual judge and whether that individual judge would therefore have the ability to hire and fire their marshal, or whether the marshals are county employees who would develop their contracts with the county for whom a senior marshal or a chief marshal would set the standards of their performance, do things like performance reviews and take care of any disciplinary action, even though every deputy marshal would continue to be assigned to one individual court and continue to work side by side with one particular judge to ensure order and security within that particular courtroom. At the Vice Chair's pleasure, I'll just summarize the provisions of SB 450 before I turn it over to Mr. Hawks, who is, of course, a Deputy Marshal in the 8th Judicial District, who I think can help explain a little bit more the history and the need for the bill. So the bill does 5 main things. First, it provides that the bailiffs and deputy marshals are to be considered local and government employees in counties with a population of 700,000 or more. That's just a very clear policy statement indicating that they are county employees and they're not employed by any other governmental or non-governmental agency. Secondly, the bill provides establishes provisions for assigning the bailiffs and deputy marshals. So this replaces the current system where they are technically appointed by a judge or a justice of the peace. And again, going back to my analogy of the Nevada Legislature, it's more akin to our system where they are assigned to a particular office, they're assigned to a particular department, but that individual judge doesn't take any kind of formal action to appoint a specific deputy bailiff or marshal. Third, I think is an important point, the bill removes the requirement for deputy marshals to comply with duties prescribed by judicial officers. So essentially, this is ensuring that the standards of the standards of performance are not set by a judge, but they're set by marshals, by a chief marshal who understands the law enforcement needs in a unique place like a courthouse. It shouldn't be that marshals are having to look to judges to make decisions about how to secure a courtroom, how to properly assess threats, how to handle disruptive people in a courtroom. Certainly, there is room for a marshal and a judge to work together to understand the particular needs of that courtroom. But in order to preserve our public safety, it's really important that we have law enforcement officers, post-certified chief marshals setting forth the requirements and the job responsibilities of the deputy marshal or the bailiff. So that section of the bill, which strikes the language saying that the marshal complies with duties prescribed by the judicial officer, is not intended to suggest that they don't work directly with the judge, but to clarify that we are not going to we are not going to put the onus, frankly, on judges to establish security protocol for their own courtrooms. That is outside of a judge's job. A judge should be able to walk in on the first day that they serve and sit on the bench and know that whoever is standing in the back of her courtroom or his courtroom, that deputy marshal, has been properly trained, certified, and follows a certain code of conduct in order to keep order and security within the courtroom. That should be the marshal or the bailiff's duty, and that should be both centralized and uniform across every courtroom within a particular courthouse. The fourth thing that the bill does, or the last two things that the bill does, are just modernization. One, it authorizes bailiffs and deputy marshals to provide service. So if you've ever seen a movie where somebody slaps a piece of paper down and says you've been served to suggest that someone else is being sued, that's what we're talking about. It is an important function to be able to ensure that individuals who are being called into court are properly advised of that, and so this modernizes the language in this section of the NRS to ensure that deputy marshals are able to effectuate service. And the last thing that it does is it removes the bond requirement for marshals and bailiffs. When the Nevada Constitution was first written and the first bailiffs were being hired back at the turn of the century, we used to require that they would put down something like $100 of bond when they were first hired as the marshal, I guess to ensure that they maintain some kind of impartiality, but this is a pretty antiquated requirement to have employees placing bonds in order to be able to take their posts and fulfill their job duties. So the bill simply removes that requirement. And with that, with your permission, Vice Chair, I would like to turn it over to Deputy Marshal Hawks.
Good afternoon, Mr. Hawks. Whenever you're ready.
Oh, okay. Thank you. Good afternoon, Vice Chair, committee members, Senator Scheibel. Thank you. Senator Scheibel presented it very well. There's not much more I could add to it other than give you a little history of the deputy sheriff bailiffs, and in '07 changed to deputy marshals with AB 139. We think it was an oversight at that time that our employer wasn't solidified, so that we haven't been in limbo all this time. And it would have given us the opportunity to then set the standard across every courtroom that we service. Every facility we service, we have the Greystone Building, Family Court, the Juvenile Justice Facility, we cover that when they do exchanges and stuff on the weekend. Also the Regional Justice Center, all of the outlying justice courts, we cover them. The changes of this bill would then give us an opportunity to make sure that we have a standard across the board that is the same. So no matter which courtroom you walk into, as the officer protecting that courtroom and the public coming into it, the standard would be set so that you knew exactly what was going on. The judiciary has not appointed anybody under the statute since 2007. We've had a pool of available officers that are post-certified when they come to us, or we send them to the academy to become post-certified. So we have a pool of officers, and the word appoint is they appoint them to service of the four corners of that courtroom. It's the same for myself. I'm assigned to District Court 12 with Judge Levitt. I'm assigned by the agency. She doesn't want an appointed marshal. She believes that everybody should be under the chief judge, or I'm sorry, the chief marshal, so that we can set that standard and maintain it. That's pretty much it. I will answer any questions that you may have.
And I'm also here to answer questions.
All right, thank you both for the presentation. Members, any questions? We'll start off with Senator Ellison, please.
Thank you, Mr. Chair, Vice Chair. Question I have, maybe you can answer. These things get in the way. Question I have is a marshal, you know, and you're a server. I know it's a lot of places here in Nevada, they're not post-certified, they don't have to be. But what I don't like is, you know, they're out there in the public and they're serving people with papers, either divorce or lawsuits or whatever, and where they don't go to post, they can't carry. And I think that's a problem. I know you guys are just saying you're post-certified, so you can carry anywhere you go. But some of the places, the servers in rural Nevada are not. Can you speak on that, or any idea? Because to me, it seems like we're putting people in harm's way. Thank you.
So Melanie Scheibel, for the record, I'll try to address this question. I think that our service provisions in the Nevada revised statutes have a lot of different facets, and really anybody can effectuate service who's over the age of 18. And so developing new policies would be a little bit outside the scope of this bill to ensure that people effectuating service in rural areas were allowed to carry while they did that. If you're talking about marshals in rural areas that are effectuating service but aren't allowed to carry, again, I think that would be a different policy proposal to change that rule.
Follow up, sir?
Follow, please.
Yeah, and I didn't know if they're under marshal or just deputies, servers. I don't know that. But I know that I've had a couple of them through the years come to my office complain that, you know, that sometimes people get upset with them and really upset, and they have no protection whatsoever. So that's why it was just a question to ask, because, you know, with the marshals that you guys have, they're post-certified. They can do anything. So thank you.
Senator Scheibel, could I address Senator Ellison's question?
Yes, fine with me. I think the vice chair is nodding too.
Please proceed.
Thank you, Vice Chair. Sir, you're correct. We have in the statute a provision for process servers. Prior to becoming a deputy marshal and a deputy sheriff prior to this, I was a deputy constable, worked for Bobby Gronauer at the Las Vegas Constable's office. We were all post-certified officers. We could go anywhere within Clark County, do any service. You are correct in the stance that there are process servers out there that are not deputies. They are not able to carry unless they have a CCW. And those would just be simple process servers, not post-certified peace officers.
Thank you. Members, any additional questions? Seeing none, Madam Chair, thank you, and Mr. Hawks, thank you for joining us. At this time, I'd like to invite those wishing to testify in support of Senate Bill 450 in Carson City or Las Vegas, if you could please come forward.
Thank you, Vice Chair, committee members.
We'll start here in Carson City, and then we'll jump back to Las Vegas. Good afternoon, welcome.
Good afternoon, Vice Chair, members of the committee. My name is Troyce, Troyce, last name Krumme, Krumme. I'm the chairman of Las Vegas Police Managers and Supervisors Association. I'd like to thank Senator Scheibel for bringing this bill. I think it's important. I think this clears up the distinction regarding a potential violation of separation of powers. Law enforcement has a responsibility to serve within the executive branch, and having these city marshals, or excuse me, these county marshals answering to directly and under the guise of working for the judiciary, I think causes a lot of confusion within the state law, and I think this bill will do a lot to clean that up and have them placed where they should appropriately be. Thank you.
Thank you for joining us. Good afternoon.
Good afternoon, Vice Chair Flores, members of the committee. My name is John Abel. I serve as the Government Affairs Director for the LVPPA, also for the City Marshals as well. Collective bargaining is proven to aid in workers' workplace issues and better pay and better workplace services. For that reason, we support the bill. Thank you.
Thank you for joining us. Good afternoon. Welcome.
Good afternoon, Vice Chair, members of the committee. My name is Dan Gordon, D-A-N-G-O-R-D-O-N. I'm the president of the Nevada Police Union, and we fully support SB 450. Thank you.
Thank you for joining us. Good afternoon.
Good afternoon, Mr. Vice Chair, committee members. Jason Lesher, L-E-S-H-E-R, with the Washoe County Sheriff Deputies Association, and mirroring the comments of our colleagues, I'll just give that a ditto. Thank you.
And thank you for joining us. Seeing no one else in Carson City, we'll go to Las Vegas. Good afternoon. Welcome.
Good afternoon, Vice Chair. My name is Michael Samt. I'm an attorney, and I'm representing myself, and I'm in support of SB 450. Just a little bit of a background. I've been practicing law in the state of Nevada for 24 years. I have, over the course of my career, have had many jury trials in the courthouse. Specifically, when you're dealing with jury trials, you're always constantly in court. During the time period that I've tried my cases, one of the things I've noticed over time is that there has been a inconsistency on how each courtroom is conducted. This is an issue, of course, for two reasons. First of all, as a matter of public policy and public safety, we have no clear standard of performance among the bailiffs that are there, which means the following. I've asked and spoken with bailiffs specifically about how they are reviewed in terms of their performance in each courtroom, and there's none. So as a result, each bailiff is left to their own devices in each courtroom, and they're left to the direction of the judge to which they're in the courtroom for. I think this bill relieves judges of the burden of having to make decisions with regards to security measures in their own courtroom. It allows judges to be judges and to do judges stuff, and it also allows the trained security and marshals to do security stuff. I think as a result of this bill, we avoid circumstances like what happened with the Honorable Judge Mary Kay Holthus, in which there was a clear mess up in terms of security protocols because there were no security protocols. This, I believe, at the end of the day, would be something that would serve our community here in Las Vegas and Clark County. And as a result, I would support SB 450. Thank you.
And thank you for joining us. Is there anybody else wishing to testify in support of Senate Bill 450? Seeing no one else in Las Vegas, BPS, do we have anybody wishing to join us over the phone?
Thank you, Vice Chair. The public lines are open and working. However, there are no callers to provide support testimony at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 450. If you could please come forward, Carson City or Las Vegas. Good afternoon.
Good afternoon, Vice Chair Flores, the members of the committee. My name is Andres Moses, A-N-D-R-E-S, last name Moses, M-O-S-E-S, on behalf of the District Court in Clark County. We are here in opposition today to SB 450 for two primary reasons. The first being that we feel that this bill is premature. We currently have ongoing litigation with the Marshals Association. The case is currently pending before the Nevada Supreme Court. It's been fully briefed. We are awaiting an order scheduling oral argument, and then hopefully a decision. But we've been overseeing the marshals since 2007 when the sheriff in Clark County was relieved from that duty. And we've invested a lot of resources and training and in overseeing this group of employees who make it a safe environment for our litigants and our staff and our judges. The second reason is that we feel strongly that the court should be responsible for their own security. And we feel that this is an issue that the courts have inherent authority over, and we would certainly take any feedback with regard to how the marshals should be managed or supervised or trained. And the last thing I want to address is the collective bargaining component of this. And currently under Court Rule 1.53, the marshals do have a framework to collectively bargain. And if they wish to be recognized by the court, we'd be happy to entertain that and review that. And our management has always been open to that. So thank you.
Thank you for joining us. Please.
Good afternoon, Vice Chair and members of the committee. My name is Jeff Rogan, Jeffrogan. I represent Clark County. I just want to echo the things that Mr. Moses said. Since the decision in the City of Sparks case in 2013, the county has considered these deputy marshals to be employed and at the direction of the courts, consistent with that ruling. We did enter into a memorandum of understanding with the courts, specifically with regard to their control over these deputy marshals. I don't think that there's really any confusion from the county's perspective as to who's in charge of these deputy marshals. If there are concerns about specific policies that are being applied or not applied to these marshals, that's the role of the chief judge of the 8th Judicial District Court to resolve as the chief judge of that court. I have nothing more to add, but I will make myself available to you if you have any questions. Thank you.
Thank you. I don't think we have any questions. Thank you for joining us. Anybody else wishing to come forward in opposition to Senate Bill 450? Seeing none, BPS, do we have anybody wishing to join us over the phone?
Thank you, Vice Chair. The public lines are open and working. However, there are no callers to provide opposition testimony at this time.
Thank you. Lastly, BPS, do we have anybody wishing to join us over the phone in the neutral position for Senate Bill 450?
There are no callers to provide neutral testimony at this time.
Thank you. At this time, is there anybody in Carson City or Las Vegas wishing to testify in the neutral position for Senate Bill 450? Seeing none, Madam Chair, any closing remarks?
I just want to thank the committee for their time and for hearing our bill.
Thank you, Madam Chair. And with that, we'll go ahead and close out the hearing on Senate Bill 450.
And thank you so much, Vice Chair, for running such an efficient hearing. I was over there, now I'm over here, and I think you closed the hearing. And so now I will open the hearing on SB 303.
Good afternoon, everyone. For the record, I am Rochelle Wynn, and I represent Senate District 3 in Clark County. I'm here to present Senate Bill 303. I also have my co-presenter here, and he is probably best equipped to answer any legal questions and give you some more background. But just as a way of general background, I'm going to talk about the statute that we are addressing here to discuss the state's civil liability laws concerning individuals using certain types of private property for recreational activities under very specific conditions. Recreational use statutes are designed to encourage landowners to make property available for public recreational activities by limiting their liability. In fact, Nevada's recreational use statute, Nevada Revised Statute 41.510, was first enacted in 1963 as a part of a broader nationwide movement to protect landowners from liability when allowing free public access to their lands for recreational purposes, such as hunting, fishing, and hiking. Over time, Nevada's recreational use statute has been interpreted and shaped by new legislation and key court decisions, and this has resulted in a move away from the original intent of the law to a place where you now have local governments citing this statute meant to limit their liability when injuries occur at city parks. I think that's important to look at that historical history of this statute, because I think what it was meant to do has been distorted, and this is an attempt to kind of bring this back in and give more clarity to the definition in statute to allow for people to not have unlimited liability protections from things that they should be at fault in. In this case, I'm not going to get too much into some of the language of the bill, but in 1995, we can talk about Bolin v. Nevada Rock and Sand Company. It was a Nevada Supreme Court decision that also further limited the application of NRS 41.510 to rural, semi-rural, and non-residential properties and excluded urban and residential areas. Later that year, though, the Nevada Legislature amended this to apply to any premises, further expanding some of that like liability and taking it out of the rural hunting, camping, and hiking area and made it applicable to all of our city jurisdictions. However, we've seen increasingly broadening of that language to the point that brings us here today and why we need this bill. The purpose of Senate Bill 303 is to return NRS 41.510 to its original intent. The statute as it currently stands shifts liability from governments and publicly accessible property owners to injured individuals. Urban areas have sidewalks, bike lanes, and parks maintained by municipalities. And as you will hear in some of the examples that are given by my co-presenter, the expansion of this NRS shields local governments from liabilities, even in cases of negligent maintenance such as broken playground equipment, defective lighting at crosswalks, and poorly designed construction zones. Injured pedestrians, parents of children at city parks, our seniors and cyclists are left without recourse, even when there's clear negligence contributed to their injuries. As interpreted by the Supreme Court and our district courts, there's no purpose to the way that this is now being increasingly interpreted beyond limiting accountability for negligence. With that, I will turn this over to Mr. Watkins to kind of go through the proposed amended language and amendment on this bill and some further descriptions of what we're trying to accomplish.
Thank you, Chair Scheibel, Vice Chair Flores, and Senators. My name is Justin Watkins, for the record, Justin Watkins. And thank you, Senator Nguyen, for the summary of how we got here. I would like to just add in that further necessitating this bill was an interpretation by the Supreme Court just last year in 2024, in which the definition of any premise and recreational activity was so expansive as to open the door for any activity anywhere in the state that could be deemed to be recreational at some point in time may extend liability immunities to both state and private actors. That is not to say that I'm here to say that the Supreme Court got their decision wrong in Abbott. I think the decision was correct, but the language that was used in the interpretation of the language and the dicta that exists in that decision leaves a door open that I think this bill hopes to close and define exactly what we mean by recreational immunity. I'll start by saying in the state of Nevada, as in every state, there is sovereign immunity, meaning you can only sue the state or any of its political subdivisions if the state gives you permission to do so. In the state of Nevada, there are situations in which the state does allow you to sue the state for its own negligence, but there exist many different liability protections. The first would be discretionary function immunity, which is that if the state is acting within the function as described in statute and uses its discretion, they are immune from liability for using that discretion. Secondarily, even if they are negligent, there are negligent liability caps on their damages, currently at $200,000. So I use that as a framework to go through how the Abbott decision is potentially confusing to injured people and litigants without some clarification. In Abbott versus City of Henderson of 2024, a mother and her child were at a city park. The mother tripped, fell, and broke her leg in an uneven part of the playground. And in interpreting this statute, the Supreme Court said that her activity was considered picnicking under the recreational use statute as listed there, but went beyond that to say that walking, she was walking at the time, walking is a recreational activity, and that the any premise language in the statute really does mean any premise, anywhere, and that the non-limiting language in recreational activity is open to interpretation. So one is left to wonder, if you are walking on a sidewalk going to and from work, are you recreating? If you are riding a bike to and from work or for work, are you recreating? If you are traveling to Las Vegas on vacation with your family, are you recreating? And when you are go walk through a casino or on the sidewalk or a public roadway and you're injured through some hazardous condition, is the court going to determine that the parties are immune because you were recreating? Rather than go through the language of this bill specifically, we have had some very productive conversations with the Nevada jurisdictions, and it has shed some light on ways in which we can move forward, I think, and balance the interests of protecting the citizens of the state of Nevada from injuries, but also promoting the continued development and maintenance of recreational opportunities, both for Nevadans and for people who travel here for the purpose of recreating. So I will begin by saying, if you look at section 1 of this bill, well, actually, it's the only section of this bill, but subsection 1 is describing the original intent of this bill as interpreted by the Supreme Court prior to 1995, which was that it was supposed to address rural, semi-rural, and non-residential areas. I think for the purposes of moving forward with some amendment that addresses and balances the concerns that I just discussed, we would be looking towards adding state entities and their political subdivisions for any land anywhere. That would be both urban, rural, semi-rural, and non-residential, for premises that are used solely for the basis of recreational activity. So not all state land, but state lands that are used solely for recreational purposes. And I want to be clear that we are also not intending to remove the immunity that currently exists under statute for private landowners in rural, semi-rural, and non-residential areas who are granting access to their lands for recreational activities for no fee. That was the original intent of this statute. It is a good public policy that should remain so that people have access to public lands for recreation by way of access of private lands. But that immunity shall not extend to private, for-profit enterprises or any contractor, vendor, supplier who provides services for those landowners. If you are in the business of creating recreational opportunities, then you should, as a professional, provide those in a safe manner, and if you fail to do so, be held accountable. These immunities should not extend to private development or residential areas that are not state-owned. As part of the conversation with the Nevada jurisdictions, we also think it's important to, you'll see in subsection 2 of this bill, I'm sorry, subsection 4 of this bill, we were removing the non-limiting language of the definitions of recreational activity, meaning we were closing the list off to just those that were enumerated. We would open that back up. The cities and the states and the counties are developing new recreational opportunities that are not in statute. Examples would be pickleball. They're developing pickleball courts. We want to continue to promote the development and maintenance of these opportunities. And we would also work with state entities to ensure that they have direct appeal rights in situations in which their immunity is not recognized at the district court level, so that they are not caught in litigation for years, working their way towards an appeal only after trial has happened. That has been an issue that was not contemplated by this statute or this bill, but has been brought to our attention through conversations. And then lastly, the immunity should not rise to the level of gross negligence or any willful, reckless, or intentional conduct. This is simply immunity for negligence itself. As you guys are well aware, gross negligence standard is, while it still has negligence in the word, is a very high standard that requires reckless conduct or borderline intentional conduct. And with that, I will extend apologies to some of the members who are here to oppose the bill. We have not gotten to the level of these conversations to resolve this into actual language yet. And so I had to walk through with the concepts of where we hope to get and then identify that language particularly. With that, I'll open for questions.
All right. Thank you so much. Are there questions from members of the committee? Starting with Senator Ellison.
Sorry, ma'am. I have usually too many questions in my head. I do have a question, though, but if this, the way it is, and you say that woman fell and broke her leg and sued, do you think that these smaller parks and trails and issues like this, they would just shut them down, close them off, because of the liability that's out there? Could you answer that?
Thank you, Senator. Justin Watkins for the record. As we are proposing to amend this language, the answer would be if those are non-private parks, if they are owned by the state, the city, the county, any municipality, then there would not be any liability in that situation. Their immunity would remain. Specifically for the purposes of encouraging continued development.
Other questions? Senator Krasner.
Thank you, Chair. Thank you for your presentation. So I'm just trying to understand it because we went from what it was, what it's going to be, the Abbott case. Currently, does the law state that If a parent is with their child at a playground that is owned by the city, and there's some big piece of metal sticking up on the slide, and the child goes down the slide, and they cut their leg, and they have to go to the hospital and get 40 stitches, that the city's not liable?
Thank you for the question, Senator. Justin Watkins for the record. I am going to say you are correct in that the city would not be liable, but I'm just going to put one clarifier on there. The facts would matter on that situation because that may rise to the level of gross negligence, depending on what notice the city had of the condition and their failure to address that condition. If that rose to the level of recklessness, then there would be no immunity protections. Not currently under the law and not under this bill either.
And if I could just clarify, just to give you a little bit more facts about the Abbott case. So in September of 2019, Catherine Abbott was slipped while assisting her youngest child on a slide at a park in Henderson. There was a rubber surface called pour in place that surrounded the slide and the playground, park playground. The sand adjacent was not raked to the level, so it was instead of like a gradual like drop off between the sand portion and this like pour and play like rubbery surface, it was like a sharp 90-degree drop off. And so in that situation, that is what happened. The original drop off was created when the original slide was replaced in 2012. And so the edges weren't beveled, there wasn't a slope, and so it had this very steep drop off that led to this woman who was playing with her child to, be injured, and her leg was fractured in multiple places. So the city of Henderson, she sued for negligence. This was a case that didn't rise necessarily to that level of gross negligence, but it rose to the level of negligence. And the way that the Supreme Court interpreted this NRS was they found with the city of Henderson that this was in fact a defense. And so all of her, remedies were foreclosed from that. Another example is Anthony Ozuna, who was killed while riding his bicycle on a busy Las Vegas street in a bicycle lane. He struck a traffic cone because the portion of the street, including a marked bike lane, was unlawfully or incorrectly closed off by traffic signs and cones and barricades. And then that wrongful death lawsuit brought by that gentleman's estate. The court ruled in favor of the contractor based on this same interpretation of NRS 41510. Obviously, what we're trying to do is get back to the point where in situations like that, there are some protections for these people that are injured in areas where in any other circumstance, you would assume that they would have the protections of the court. They would have the protections to be able to sue when there is negligence. That may not rise to gross negligence, but obviously there were circumstances that could have been prevented, that could have prevented the injuries that, happened to these individuals. Those are just kind of two examples. Obviously, I think we still have some work to figure out how we can thread that needle where we were before 1995 and where we are now. But that's what we're hoping to be able to tighten up that language. So people in our rural communities that are hiking and biking and playing pickleball, even in the urban communities, are still under the original intent of the legislation, but we're not precluding the situations like the two situations I described before, where arguably those people should be able to get their day in court to have those kind of issues addressed.
Senator Hansen.
Thanks, Madam Chair. Now, in your testimony, you're just saying you're going to put back in the strikeout includes but is not limited to. Is that going back in? Is that what I understood?
Thank you for the question, Senator. Justin Watkins for the record. That's correct.
Good, because there's a whole lot of recreational things that obviously are not listed there. The other question is all remedies that we just mentioned for the lady that broke her foot. Did she have any private insurance or anything like that? Do you know of?
Thank you for the question, Senator. Justin Watkins for the record. I wasn't the attorney on that case. I don't know the specifics.
Okay, that's another remedy that people can have. So I got a real real heartburn with some of this stuff, because obviously, even with the current law, when the state or government agency or whatever is grossly negligent, for example, the example that Senator Krasner brought up, if the city knowingly had some barbs sticking out on a slide and some poor kid cut his leg real severely, I have a hard time believing that if the city knew about that they would not be considered grossly negligent. So, when we're trying to thread the needle, as Senator Wynn mentioned, I'm kind of wondering if we're not going too far with this, because, I can think of 1,000 examples. Classic one would be the city people are working on the sprinklers on the football field or whatever, or some recreational field, and then when they backfill around the sprinkler thing, they leave a hole, which is very common. I've seen this many times. So you're out there playing, you fall down, you break your foot. Is that going to be considered? Currently, I think they would say that was a level of negligence, but was it gross negligence? So I'm just kind of like trying to see where that balance should be. And then last question, this has been the law since 1995. Is this the first case you guys have that you can bring up where somebody stuck their foot in a hole at the bottom of a slide that had the rubberized, Are there other cases that would indicate there is a significant problem that needs to be corrected?
Thank you for the question, Senator. Justin Watkins for the record. This is the first Supreme Court interpretation of this case in an urban area since 1995, is the only way I can answer that question. Of course, there are district court opinions that have gone one way or the other, but this is the only direction we have from the Supreme Court. And I just want to state, with the amended language that we are proposing to work out with the jurisdictions, the result in the Abbott case would not change. The result in the case of the biker on the roadway would. The roadway is not used solely for recreational purposes. Roadways would still be protected. A park that is solely developed and maintained for recreational purposes would have immunity up into gross negligence. Gross negligence standard, in my 20 years of experience of litigating, is a very, very, very difficult standard to meet. It requires some level of actual notice and then a indifference of that known danger and failure to warn.
Okay, well, the fact that for 30 years, the first case that actually made it to the Supreme Court to make a decision would indicate there's not a huge problem with it. Secondly, the cone issue. I'm not familiar with that case. I was familiar with the one about the lady breaking her foot. The cone one, though, is kind of a sensitive one because that's something we do all the time in private practice, right? We put cones out when we're going to be digging something up and, making sure nobody is accidentally going where we're going to be digging a hole or whatever. In this case, the court clearly found that the contractor, while he was negligent, had not risen to the level of gross negligence. Are you suggesting now that every contractor who may put cones up incorrectly and some poor kid runs into him on his bicycle, that will kind of now, because it will be negligent, will then fall as a liability on every single contractor in Nevada who uses safety cones?
Thank you for the question, Senator. Justin Watkins for the record. My contention is that a contractor would be treated like every other for-profit private business in the state of Nevada, and that is, if you're negligent, you're responsible for your actions.
I got it, but right now you have a gross negligence concept for a recreational thing. That's what we're addressing in the bill, right? In this case, a young man was riding his bicycle in a bike lane that would be considered recreational. The contractor, I don't know the details of the case, but what it sounded like, you had cones that were put up improperly. Kid crashes his bike, and in a horrible situation, passed away. Is that correct? And therefore, there's a raised, significantly raised bar there, I guess you could say. Like, look, man, if you cause somebody to die versus even hurting your foot in the hole, I think that raises the bar. But even in that situation, because it was considered recreational, the court ruled that it was not gross negligence.
If I could answer this, Rochelle Wynn for the record. The reason I bring that up is because I think that's a perfect example of a gross distortion of what this bill was meant to do. It was, if you look at it, like I said, even with the Abbott decision, what our amendment does is it wouldn't change that ruling. But it would potentially change this ruling because right now that construction company is taking advantage of a recreational park law that was never intended to be applied to a bike lane on a road. Like, that is not recreating. That's not all of these things that are included in the statute right now, like pickleball or hunting or fishing or trapping. This is someone on a public roadway in a bike lane. And so all the normal like laws that would apply to a negligent situation would apply to that construction company who erroneously, or whoever that company is, that's a private company that's liable. So, you know, my argument would be is this law was never intended to protect private companies from like error, and it is being interpreted that way now. And that's why I think it's important to narrow this down, because they're trying to take advantage of the same protections and liability protections that the city of Henderson would have at its park.
My God, I'm not sure, since I don't know any of the facts of the case. It is interesting that it did go to a court, and even though you had a private party, they used this recreational statute, from what I heard. I mean, I haven't got any of the details. But I would say I have a hard time believing the court, maybe the contractor was actually working as a subcontractor for the city in a certain situation, and therefore the liability could theoretically pass through the contractor to whoever the government entity was. So I don't know. I mean, I can see what you're trying to do here. I'm just kind of worried about weakening the gross negligence part of this statute. If we need some specific carve-outs for private parties, I can see it, but the way this thing's worded, I think every municipality in the state of Nevada has a huge spike in potential liabilities on things that currently they have, unless it's grossly negligent, they have protection. So anyway, thank you, Madam Chair.
If I may, Madam Chair, just to address your comment, Senator, the gross negligence standard is largely encompassed in statute currently. It says any willful conduct that a failure to warn or to make safe. So if somebody were at a gross negligence standard today, I believe that a court would not find immunity protection. So I'll just say that we're clarifying the language to just include gross negligence, which is actually the standard that exists in governmental discretionary function immunity. We're just mirroring the language there. So I don't think it makes a big shift in where the state's liability begins, factually.
Okay, no, we can, once I see your amendment, maybe we can pick this up again. The problem is we're talking on a conceptual amendment that nobody's seen except you guys apparently. So thank you, Madam Chair.
Other questions from members of the committee? All right. Then I think that brings us to the conclusion of your presentation and questions. And I will go ahead and open it up for testimony in support of SB 303. Anybody wishing to give support testimony in person in Carson City or Las Vegas is invited up to the front now. I'm not seeing anybody, so we'll go to the phones for support testimony on SB 303.
Thank you, Chair. If you would like to provide testimony in support of SB 303, please press star 9 to take your place in the queue.
Good day, Senator Scheibel and members of the committee. I just want to make sure, this is Dora Martinez. I was trying to dial in and I don't know, I didn't hear. Is this the Senate bill that Senator Wynn is doing?
This is I believe it's a committee bill that, yes, Senator Wynn did present it.
Okay. Yes. Okay. Thank you. I'm sorry, Senator. I'm sorry. This is unorthodox, but I was trying to dial and listen into YouTube and dial in. So, again, this is Dora Martinez, and I wholeheartedly, we from the Nevada Disability Peer Action Coalition, we do use a lot of a state park. As some of you may know, I am blind, and some of my friends do use wheelchairs and some walkers and can we go out and do self-care at the park. We walk around, listen to birds. And so we wholeheartedly support this bill. And thank you. And I'm sorry for the confusion earlier. I just want to make sure I was testifying for the right bill. Thank you. Have a good day.
There are no other callers to offer support testimony at this time.
All right, then at this time we will go to opposition testimony. I understand that we have some presenters here from some of the local government jurisdictions that would be affected by this bill. I have agreed to allow them a little bit of additional time to make their remarks this afternoon. They have cleared this with me in advance in case anybody's wondering why they're getting this special treatment. And so please go ahead whenever you are ready. And also, as a condition of the additional time, you will have to answer any questions from the committee. You also have to turn on your microphone as one of the conditions.
Condition accepted. Senator Scheibel, good afternoon. Members of the committee, good afternoon. My name is Brandon Kimball, BRANDON KEMBLE for the city of Henderson, for the record. I want to start by saying we're here to testify about the bill as written. We appreciate and are looking forward to working with former Assemblyman Watkins and Senator Wynn and other proponents to work towards those goals and those provisions that former Assemblyman Watkins mentioned, but we're just not there yet. So we're here to talk about what the bill as written and what you have in front of you would do. Senator Wynn eloquently laid out the long history of the bill, and we'll concede that the bill has been amended many times throughout history, each time to broaden the types of recreation activities and lands that are covered by those immunities. The only limitation that was adopted in 1991 amendment was to make it clear that the intent of this statute is to encourage public recreation opportunities. The 1991 amendment made sure that private landowners could not exploit the statute for their profit goals. This bill, as written for the first time, reduces the opportunities for public recreation. And for that reason, the cities and counties from north to south, Henderson, Reno, Sparks, Clark County, North Las Vegas, and others are opposed to the bill. The purpose of the recreational land use protections is simple but essential. Past Nevada legislatures, as well as other legislatures from around the country, have long operated under these principles. It's good to encourage the availability and development of recreational lands and activities for the public. We understand that recreation and adventure come with inherent risks, but if landowners face lawsuits and liability from these inherent risks, they are less able and less likely to make land available or provide recreational opportunities. These concepts are the same whether the land is public or private and whether it's rural or urban. The trend across the country, this is just not Nevada, is towards liberalizing these recreational use statutes to include more types of land and more types of recreational activities to broaden the shield of liability against lawsuits that would otherwise drain public resources. While SB 303 as written would remove urban areas and structures from its protections, more states are adapting to modern trends by broadening, not narrowing, the types of lands covered under the recreational use statute protections. Take the trend of providing protections for paved recreational trails in states like California that adopted California Government Code Section 831.4, granting immunity for recreational trails, paved walkways, and paths. Other jurisdictions have responded to lawsuits that have limited their statutes, not by narrowing them, but by broadening them. In 1996, a Virginia court ruled that its recreational use statute didn't apply to urban improved lands. And after suffering for 2 decades under increased litigation and liability, Virginia amended its recreational use statute, Virginia Code Section 29.1-509, to include urban recreational lands, including parks, trails, and it clarified that it protected both public and private entities. More recently, in 2024, following a lawsuit in Oregon, where the Oregon Supreme Court ruled that an improved public trail was not protected by Oregon's recreational use statute, Oregon responded with Senate Bill 1576, clarifying that its recreational use statute covered public and private entities, landowners, and included playgrounds and trails as well. There's more examples of states responding to lawsuits and court decisions that attempt to limit recreational protections, like Connecticut, Pennsylvania, Rhode Island, just to name a few. Rather than encouraging recreational paths, SB 303 as written asks the legislature to endorse more paths for liability in lawsuits that probably don't make things safer, but certainly impact the recreational opportunities and recreational evolution as they drive up the cost of dealing with reducing risk. For instance, lawsuits in Iowa led to a ban on sledding in all but 2 of Dubuque, Iowa's 50 city parks. Last month in Cortland County, New York, officials removed all playground equipment from Dwyer Memorial Park in response to a lawsuit despite the county's belief that it had complied with all the safety standards for its equipment. And in Chicago in the 1980s, following lawsuits and increased insurance premiums, Chicago simply tore down all its jungle gyms and slides greater than 6 feet tall. Parks and recreation are the backbone of the city of Henderson. Our Henderson residents love our parks. I don't think there are many places the government earns 90% plus approval from its residents, but in Henderson, 92% of our residents love the quality and maintenance of our walking and biking trails. 92% are happy with the quality of the youth recreation programs. 95% rave about how we run, maintain, and make our parks and aquatic facilities available. We have 74 world-class parks within a 10-minute walk of most of our residents, miles and miles of trails. We want all of our residents to have maximum access to our 2-time National Gold Medal Award for Excellence and 3-time CAPRA certified parks and recreation system and facilities, whether they live in one of our rural preservation districts or overlooking Boulder Highway. This bill makes that harder and more expensive. For instance, the city is currently planning an innovative adaptive use park with a focus on ADA accessibility and a cutting-edge Ninja Warrior-style park, obstacle course-style park as well. If SB 303 passes, these types of projects will need to be reconsidered in light of an altered legal and liability landscape. Our residents want projects like these. They want splash pads, skate parks, dog parks, zip lines, climbing walls, all sorts of recreation that comes with inherent risks. Risks that they're willing to take on that would be liability nightmares without the protection of our recreational use statutes. I'm sure Henderson residents aren't the only ones who love their parks. All the cities and counties in Nevada want to provide parks and open spaces in forms that suit their residents. Survey the residents and I'll wager you'll find they love their parks and open spaces and they want more of them. Because for most of them, their backyards are getting smaller and the cost of private recreation is only going up. SB 303 as written makes providing public access to recreation harder, more expensive, and less likely to happen. And the bill as written draws this distinction for the communities that need recreation the most, are urban communities that don't have the ability to walk out in a field where a game of baseball can break out. They need intentional recreation from their municipalities. So as written, SB 303 we're opposed, but we're hopeful. We've had these discussions with Assemblyman Watkins and others, bill proponents about amendments, and we will keep that dialogue going for you. Jeff Rogan from Clark County DA's office is going to step through some of the technical effects and problems with the bill. Brandon Sandahl from the city of Sparks is going to give you a view from a little bit closer to home, and Nathan Yuliot, Parks and Recreation Director from Reno, is going to discuss some more impacts of SB 303. I'll turn it over to Mr. Rogan.
Thank you, Chair Scheibel, Jeff Rogan, on behalf of Clark County. That's Jeffrogan. I will keep this as brief as possible. Even if you think that recreational immunity statutes should be reformed for some of the reasons that were presented by Mr. Watkins and Senator Wynn, this bill really isn't the way to do it. This bill instead creates unworkable, ambiguous standards that litigants and judges and justices of our appellate courts are going to have difficulty interpreting and applying to cases. And in particular, as it applies to local governments, I'm talking about the definition on page 3 and 4 about urban public infrastructure. That's the section of the bill that really undermines our ability to provide park services in our communities. This definition is very problematic because if you read it, it's very complicated and ambiguous. It tells us that if there is public land that's located in an urban area, which is defined as not rural, semi-rural, or non-residential, and it's supported by funds or in whole or in part from our government, And the premises have been improved for the primary purpose of allowing people to engage in recreational activity or allowing people to access nearby land for recreational purposes or for transportation, daily living, or employment or work-related purposes. Then it loses the protection of our recreational immunity statute. I can say as an attorney that is a very, very complicated definition and is a fact-based definition. It would cause the court very much confusion as to whether land falls within the protections of recreational immunity or it doesn't. And in particular, it's problematic because it doesn't define what we mean by rural, by semi-rural, by non-residential. When is a land located in an urban area versus a semi-rural area? The bill doesn't tell us. At what density does an area transition from semi-rural to urban? Is it 4 dwelling units per acre, 8 dwelling units per acre? We don't know. The bill does not tell us. What does it mean to be supported by public funds? If a city or a county gives a $10,000 grant to a nonprofit to build a $50 million recreation center, should that recreation center lose any immunities that it has because of that one $10,000 donation that's just a splash in the entire cost of that recreation center? It's unclear from this bill, but presumably so. So the bill does not give us the answers to these questions, which means it's left up to our courts. And our courts throughout the state will come to different conclusions. You heard from the bill proponents that this is supposed to be a way to provide uniformity throughout the state. It will do exactly the opposite. And let me give you a couple examples of why. In Clark County, we have our beautiful Wetlands Park. Our Wetlands Park sits on that, I would say, urban to suburban divide. To the west of Wetlands Park is a typical suburban neighborhood. To the east of Wetlands Park is open desert. Under this statute, do you know whether Wetlands Park is in an urban community, a semi-rural community, or somewhere else? I think judges and lawyers could come to different conclusions, and that is a problem, a huge problem with this bill. Additionally, a lot of our trails run through many different types of communities. Some would consider them rural, some would consider them urban. Does that mean that parts of our trails are protected by recreational immunity and parks are not? We don't know, the bill doesn't tell us. So why is that bad? Well, immunities are supposed to be very simple to apply. Immunities aren't simply defenses from liability. They're supposed to prevent from a lawsuit from being filed in the first place. They're supposed to be easy to understand so that judges and litigants know whether they should bring a claim or not bring a claim. Right now, a recreational immunity statute is very simple. What are the premises that this injury took place on, and was the person engaging in a recreational activity as defined in the statute? That's very simple, and that's why motions to dismiss are either granted or denied at an early stage based upon those very two straightforward questions. With this definition of urban public infrastructure, we lose that simplicity. And what will happen is judges will throw their hands up and say, parties, you need to figure this out through the discovery process, or in fact, at trial. We'll let a jury decide. And by that point, we've lost the purposes of the immunity in the first place. The second reason that we didn't like this bill was the closed list of recreational activities. But we've heard today that the trial attorneys and the proponent are willing to amend that through our conversations to remove that, so I won't go into it in great detail. But in sum, I think that this bill, based upon its definitions and its language, creates more problems than provides solution. And as my colleague from the city of Sparks will now tell you, if passed, this bill will also cause our local jurisdictions to reconsider what types of recreational activities should be provided to our constituents and, in fact, your constituents.
Thank you, Chair Scheibel, members of the committee. Brandon Sendall, Brandon Sendall. I am a senior assistant city attorney from the city of Sparks. I think we're all familiar with what's happened with the insurance industry over the last few years. Even on our personal auto insurance, homeowners insurance, renters insurance, rates are drastically increasing. The same is true for government entities. The city in the last couple of years has had a lot of difficulty getting reasonable and affordable insurance coverage, and with what this bill does, especially as presented, there are very real conversations going on about shutting down at least certain public facilities, parks, trails, There's been discussions about the trail system, the Tahoe Pyramid Trail System, the walkway around the Sparks Marina, Golden Eagle Regional Park. So at the risk of spilling into Assembly Joint Resolution 1 and the property tax issues, the structural funding issues in the state, it's been no secret, especially up north, that local governments are not doing well right now, especially within Washoe County because of our geographic limitations on growth. So right now, as we speak, our mayor, city council, city manager's office, city attorney, all of our department heads are in a workshop right now trying to figure out how to deal with the structural deficit. Many reasons, one of which is the PERS increase, but it's just stagnating revenues at this point without significant growth. And as a reminder, for context, we are in a Dillon's rule state where cities do not have the power to take action unless the state's given them that authority. Specifically, cities cannot raise taxes. So we have the pot of money that's given to us under state law each fiscal year. But in that same context of stagnating revenues, increasing or decreased staffing, because I can tell you right now, it has not been a secret. Layoffs are happening, and the extent in which departments, that's being worked out right now, but it looks like, at least partially, it's across the board. And that includes public works maintenance and parks maintenance. Now, that's not to say we're just going to throw our hands up and not maintain parks, but we are dealing with a limited bucket of money in each fiscal year for ongoing maintenance. We're talking about a crash at a skate park, a sledding collision at a public park. I live off Wedge Parkway in South Reno. Those are popular hills in county parks. That would be a serious source of liability for the government entities. Now, we understand the desire to want to make people injured whole, but it has to be weighted against the acknowledgement that government entities are managing hundreds, thousands of acres of parks. One of the biggest complaints we get in Northern Nevada is the lack of flat fields for soccer, softball, and whatever team sports. At what level do we need to shut down a field if there are gopher holes, marmot holes? A kid comes out with a shovel and starts digging a hole, and it creates a lot of uncertainty. And the city of Sparks is very worried. To be blunt, I mean, I can't speak, even for the city of Sparks, it's being worked out right now. I can't speak for the other government entities, but if this passes in its current form, and I appreciate Mr. Watkins has brought up some amendments here, but the city of Sparks may become uninsurable, and we are absolutely looking at closing public facilities. I will chop off the last part of my presentation because I believe we are running out of time. Thank you.
Yes, and before you get up, sir, we do have a question from Senator Hansen.
City of Sparks is near and dear to my heart since I'm a native of the city of Sparks.
Yes, sir.
So, I know you guys are facing like a 10% budget deficit. I think I heard it was $18 million. And that's under the current law. So your testimony is that if, in fact, this law essentially eliminates the gross negligence statute, that you guys are going to see a further escalation of insurances and the possibility from other testimony that you're going to see the need to shut down recreational areas such as playgrounds and slides and things like that, where there is an enhanced possibility of not only negligence, but now, get rid of the gross negligence, any negligence, now the city could face a lawsuit. Is that correct?
Yes, those conversations are definitely in place.
Okay.
Name on the record for us, please.
Oh, I'm sorry. You, not me.
Oh,
My name's Ira Hansen.
Sorry, Brandon Sendall, City of Sparks. Yes, those conversations are happening. Nothing.
Okay, no.
We are working out the fiscal year budget as we speak.
Okay, so in other words, what we're trying to do here could theoretically further eliminate opportunities for kids in the very areas we're talking about to have recreational opportunities provided by the city, because of the money, instead of going to help build parks and things like that, will instead go to insurance policies, correct?
Yes.
Has anybody had, by any chance, from any of the municipalities approach an insurance carrier to say, if this law passes, what will our insurance rates do?
Not yet, and that would be the next step. We would need to work with our risk management division, our insurance carrier, to see the extent to how much this will affect it, whether it's an increase in deductibles, an increase in premiums, or just insurance companies withdrawing from the market, which is already happening.
And we need your name
So
again.
you won't see a reduction in price.
All right, Brandon Sendall, City of Sparks.
Well, one thing's for certain, you won't see a reduction in your insurance costs to maintain the same level of policy. So thank you, Madam Chair.
Before you leave, since we're taking a little pause at this moment, I'm going to see if there are any other questions from members of the committee for Clark County, City of Sparks, or City of Henderson at this point. Go ahead, Senator Ellison.
Thank you, and I thank you for your statements, because I was worried about this, and I brought that up at the very beginning. What scares me is trails, because if you get a bunch of kids on bicycles on trails and they wreck, then the liability is still going to go back on that city. Is that not correct?
As submitted, yes, it would. As Mr. Kimball said, we are concerned, especially with trails and grass fields, because I'm sorry, I lost my train of thought. But yes, Brandon Sendall, City of Sparks.
And then I know this is not in your area, but we've got several bills that looking at trail that's going to be up in the Tahoe area. That could affect them also. And they're pretty long trails that they're planning on doing walking and biking and that kind of stuff out of. Wouldn't that happen there too?
Yes, it's a big concern for us.
Yeah. Okay. Thank you, ma'am.
Other questions from members of the committee? I just wanted to clarify for the City of Sparks, you know, about the projected cost. Do you have an estimate for how much this would increase insurance premiums? Or, I mean, have you done a look back for the last 10 years and how many lawsuits you would have had to pay out had this been the law at the time?
No, it's hard to know what lawsuits would have been filed that weren't. We have not had that conversation yet with our insurance carrier. I believe this bill just came out, what was it, about 3 or 4 weeks ago. And we are scrambling on the budget right now, but that would be a discussion very soon.
So the budget problems remain whether or not this bill passes, right?
Yes, I think this would exacerbate the problem.
Okay, understood. Senator Lang.
What kind of schedule are the municipalities on and upkeep for parks? Because as I go around, I see new parks that look nice and beautiful. I see other parks that were built a while ago and haven't had any repair done to them. So how can we assess whether these lawsuits are happening? Because there hasn't been a regular schedule of repairing parks as we repair our homes and keep them nice. You know, parks need the same kind of care.
Madam Senator, if I may, I believe Nathan Yulia, the Parks and Rec Director from Reno, or Mr. Kimball would be better suited to answer that.
Brandon Kimball, for the record. Senator Lang, thank you for the question. The maintenance schedules will vary by jurisdictions and who has the ability to afford different levels of maintenance. So it's so broad I couldn't really tell you. In the city of Henderson, we have a number of area maintenance coordinators assigned to each park. There's usually daily visits to each of our parks in Henderson, but in Henderson, we're a jurisdiction that is able to focus at this point on parks, but those costs are rising, and it will become more and more difficult to comply with those schedules. But different schedules for different folks based on what their and focus are.
Thank you. I just, in reference to this bill, I would think if a municipality is building parks, they build into their budget the upkeep it's going to take to keep those parks in good shape so we have the least opportunity. I mean, kids are kids in parks, and so there are going to be things that happen. But I just think that if we can't upkeep the parks, then we shouldn't build as many.
And Campbell, for the record, appreciate that. And this bill, we do that with budgets, right? We do try to forecast the cost for maintenance for those parks, but it is difficult to forecast how a bill like this might affect that. So if we go in and allocate an amount for maintenance in the park, a $200,000, $400,000 lawsuit would absolutely blow away the cost that we apply to the maintenance of that park.
Sure. Senator Ellison.
Thank you. And that brings up a good valid question because, usually the planning commissions dictate or direct developers to put in parks. And that creates another problem of its own because, in Elko, if you're putting a subdivision in, they'll make you put in some kind of park or recreational area that is going to create another burden back to you guys as you work. Is that not true? I know that happened in outside Elko, and that I know for a fact.
Senator Ellison, Brandon Campbell, for the record. Yeah, through all kinds of development requirements, agreements, city plans, those types of parks are required. The developers sometimes take on the cost of building those parks, but it's usually left to the jurisdictions to maintain those. So we get a great, we can dictate the standards, we can have the park built, but it's ours to maintain, going forward in most cases.
Yeah, thank you.
Other questions? So I wanted to clarify with everybody in opposition, the phrasing in subsection A of subsection 5 of section 1, the whole bill is only one section. So we're talking about page 3, line 11, where the current version of the bill strikes out includes but is not limited to. And we heard in the presentation that the intent was to leave that in. Was that your understanding as you were analyzing the bill, that it would still be includes but is not limited to, and those lists of recreational activities?
No, as we were preparing, our understanding was that was going to be restricted to a closed list. Sorry, Brandon Sendall, City of Sparks, for the record. I'm learning.
Thank you, Senator, for the question. Jeff Rogan, for the record, Clark County. When we were preparing for our opposition to this bill, we were under the understanding that it would close off that list. And as Mr. Watkins rightfully told you, that was a problem for us because recreational activities, they grow and change over time. And the example that he used, pickleball, is one of the ones that I used too. I think 5 years ago, I'd never heard of pickleball, but now in Southern Nevada, it's the fastest growing recreational activity. A closed list would mean that we would have to come back to you every 2 years with a whole new list of things that we think are recreational, and that's not something that we wanted to. But in our conversations, they were agreeable to, they recognized that issue, and they were agreeable to removing that provision that would have closed the list of recreational activities.
Okay, thank you. All right, let's continue with testimony. Whoever is next, please. We'll stay here in Carson City for now, and then we'll go down to, I see we have one person in Las Vegas. So we'll finish up here in Carson City and then go to Las Vegas.
Thank you. Chair Scheibel, Nathan Olliott, Nathanullyot, City of Reno Parks and Recreation Director, for the record. Being in Parks and Rec, we're usually used to getting the leftovers, so I'll try to make this very quick and give you the 1 minute version. There's the benefits of parks in our community extend from economic, health, environmental, and public safety. This bill is written, provides some challenges to that, where we would, as our colleague from Sparks said, we may have to make decisions if it is as written put into place, where we may be closing off portions of the Tahoe Pyramid Trail that run through the city of Reno just because it starts to go through an urban space. It's not designed to be a perfect flat trail all the way through. So there would be some difficult decisions to make there, along with our playgrounds, where a portion of a playground structure may be broken, and it may require now that we would close off the entire section rather than just to close off that section that was damaged or broken in that short term. Replacement parts for playgrounds can take 6 to 9 months to fabricate, as many of the playgrounds are outdated and there are not just parts sitting on a shelf. So it's very important just to understand what this could do. As my colleague from Sparks said, we've had about 2 to 3 weeks from my perspective to start preparing for this, but it was, as written, a quite alarming thing for us to consider.
Thank you. We'll go down to Las Vegas.
Good afternoon. Thank you, Chair Scheibel, and thank you to the members of the committee. Good afternoon. My name is Chris Kraft, CHRISCRAFT. I'm a senior deputy city attorney for the city of North Las Vegas. First, North Las Vegas would echo the sentiments of my counterparts. The main concern is the impact this would have on our provision of services in the form of parks, which are of enormous importance to our residents. Increasing the city's liability for accidents which occur on our premises run the risk of decreasing the amount of parks that we can maintain. I also take issue with the proposed bill, and this is the version that was in front of us as opposed to the promised upcoming changes from Mr. Watkins, which give me some hope. But the bill sort of is telling the legislature what it meant when it recently revised NRS 41.510 to apply to any premises. That change was very clear as far as I was concerned, and the Nevada Supreme Court's plain reading of that was absolutely correct in Abbott versus City of Henderson. And the change he made makes sense. If the logic and the point of NRS 41.510 is to limit liability because there's no way a landowner can keep a close eye on everything in an open land area, that logic applies to large parks as well. And that's a very real concern for the city of North Las Vegas. Our biggest park, Craig Ranch Regional Park, covers 170 acres. A lot of that is open areas for people to do pretty much whatever they want. So changing the rules as proposed has a detrimental effect on further development of parks, as we're constantly trying to expand the size of Craig Ranch and our other parks. If we're not liable for open land, but we are for developed parks, we have to take that into account. And fewer parks is not a valid goal. Finally, I would point out that the statute in its current form does not give us leave to simply ignore safety concerns in our parks. Mr. Watkins referenced NRS 41.032 regarding discretionary immunity. However, the more salient statute that we have to rely on is NRS 41.033, which states that we do not have any liability for dangerous conditions of which we did not have an actual prior notice. However, the reality is that we do inspect and maintain our parks as well as we can. And we're not relying on just our own people either. The city hires an outside consultant to basically comb through our premises, report findings, and make recommendations, which we follow. In response to Senator Lang's query in that regard, we do this every year. Essentially, we are putting ourselves on notice and taking away our own liability. Even though we have no duty to maintain or inspect, we do it anyway because it's the right thing to do. And this approach also lines up with NRS 41.510 in its current form, which has an exception for immunity for willful or malicious actions. So we're already getting well under that bar of liability, and we're doing I think a very good job at it, and that's why you have the lack of cases that are coming down that happen with accidents in parks. I would just close by saying if the goal is safety, we're already meeting that goal with the statute in its current form, and no further amendment is needed. Thank you.
All right, I think that brings us to the conclusion of our local government testifiers, and so I will open it up once again for questions from the committee. If you all have any more questions for our local government folks, but I don't see any. All right, we'll now open it up for regular, testimony in opposition. Anybody else wishing to testify in opposition to SB 303 is invited down to the front now, and please go ahead whenever you're ready.
Good afternoon. My name is Vincent Guthreau. Last name is spelled Gutreau. First name is Vincent, Vinson. I'm the executive director of the Nevada Association of Counties, or NACO. I don't need to belabor it. I think the opposition presenters did a decent job. The bill is written. We are in opposition. I do know, as a litany of individuals have mentioned, that conversations are ongoing. We look forward to being able to not be opposed any longer, but as written, we are in opposition. Thank you.
Good afternoon, Chair Scheibel and members of the committee. For the record, Kelly McNeil, Executive Director for the Nevada League of Cities. The League has concerns regarding the bill's potential impact on local governments by expanding civil liability for landowners permitting public recreational use. SB 303 could increase the responsibility of municipalities that manage public lands, potentially leading to higher legal and financial burdens. The bill provisions lack clarity in defining recreational activity and the scope of premises, which could result in inconsistent applications and challenges for municipalities in policy enforcement. Municipalities may need to allocate additional resources to monitor and maintain lands open for public recreation under the expanded liability, impacting our local governments our local budgets and operations. For these reasons, the League is opposed to SB 303. Thank you.
Thank you, Chair, committee members. Isaac Hardy, representing the city of Boulder City and the city of Mesquite. I will keep my comments brief. And echo comments in opposition. Thank you.
All right, I don't see anybody else coming forward to give in-person opposition testimony, so we will go to the phones, please, for opposition on SB 303.
Thank you, Chair. The public lines are open and working, but there are no callers to provide opposition testimony at this time.
All right, then we'll go to neutral testimony on SB 303. Not seeing anybody coming forward in person in Carson City or Las Vegas, we'll go to the phones for neutral testimony on SB 303.
Thank you. There are no callers to provide neutral testimony at this time.
All right, I will invite the presenters up to give any closing remarks, but it looks like they're going to waive their closing remarks, so I will then close the hearing on SB 303 and once again turn over the gavel to our Vice Chair, Senator Flores.
Good afternoon, Madam Chair, and with that, I'd like to open up the hearing on Senate Bill 404.
Good afternoon. I'm still Melanie Scheibel, Senate District 9. I'm going to hand the presentation over to my incredibly capable intern, Soraya Bonner.
Thank you, Vice Chair and committee members. My name is Soraya Bonner, SORAIABOHNER, and I am before you today to present Senate Bill 404, which revises provisions related to estates. Today I'll also be joined by Kenny Lee, I think over Zoom, who works in probate in Las Vegas, and eventually Michelle Rafferty, who is co-chair of the Nevada State Bar's Probate and Trust Legislative Committee. Senate Bill 404 addresses a troubling pattern uncovered by a Las Vegas Review-Journal investigation published in January 2024. The investigation revealed how a small group of private administrators, real estate agents, attorneys, and house flippers exploited vulnerabilities in Nevada's probate process, particularly in Clark County, to profit from the estates of deceased individuals, often without family involvement or knowledge. For years, these individuals routinely secured authority to manage probate cases and sell homes through a legal process designed for efficiency but lacking sufficient oversight. Under the independent administration option, home sales and probate can proceed without a judge's approval or any competitive bidding. In practice, this has created a system ripe for abuse, where properties are often sold in short sales, undervalued, and transferred to insiders at a loss to the estate. While current law prioritizes family members to administer probate cases, it also allows anyone legally qualified to step in, often before heirs are even aware proceedings have begun. As a result, families are left out and estates are depleted through under-market transactions. SB 404 is about restoring fairness, transparency, and integrity to the probate process. It aims to ensure that families are properly notified and given a real opportunity to manage the affairs of their loved ones, and that independent administrators are subject to greater scrutiny. Probate should serve families, not facilitate private profit at their expense. This legislation closes critical loopholes while preserving efficiency for cases where heirs are in agreement. Next, I would like to provide a brief section-by-section overview of this bill. Section 1 revises the qualifications for any person or persons legally qualified to serve as an administrator, so that they may only serve if there is a finding of good cause based on evidence showing there was due diligence to find any living heir and proof of contact with any potential heirs identified. The person seeking appointment must also submit a statement demonstrating their qualifications. For Section 2, I would ask that you refer to the amendment on Nellis, or the one that's been provided to you. The amendment deletes the original language in the bill and instead requires that only a personal representative who is named in the will or as a person described in paragraphs A to F of subsection 1 of the Nevada Revised Statutes 139.040 may be granted authority to administer an estate. This amendment aims to prevent specific parties from gaining independent administration in probate cases. While these parties could still serve as administrators, they would need court authority for certain actions like the sale of real property. Finally, Section 3 requires the court, when determining whether to revoke the authority of a personal representative, to give preference to any interested person based on the order of priority set forth in subsection 1 of NRS 139.040. I'd also like to note that any of the amendments that were suggested are something that the author of the bill is accepting of. Thank you, Vice Chair Flores and committee members. No grieving family should discover that a stranger has taken control of their loved one's estate, sold their home in secret, and walked away with the profit. This bill closes critical gaps in Nevada's probate system by balancing efficiency with accountability. It ensures that independent administration, while still available for cooperative families, no longer serves as a loophole for private profiteering at the expense of rightful heirs. Thank you.
And Madam Chair, would you like for us to go to Mr. Lee? Mr. Lee, welcome. We do see you on the Zoom.
Thank you, Vice Chair, committee members. I'll just take a quick minute to provide the practitioners maybe insight into what independent administration is and how it works. Probate is a unique area of the law, a little bit different from many other areas that you may be familiar with. And so in order to really understand what has happened, what maybe needs to happen, it's critical to understand how independent administration works in the probate world. So to be clear, independent administration is intended to expedite the probate process in Nevada and reduce the administrative costs. Question must be asked, who is it intended for? Independent administration is targeted in situations where the family all gets along and there is no need to overcomplicate the probate process, causing unnecessary expense and delay. Who is it not for? Independent administration is not for situations where there are disputes, contested issues, or when there are unknown heirs. If there are unknown heirs and beneficiaries, independent administration does not work. The primary benefit when independent administration is used in the probate arena is to sell real property in an efficient manner. There are other steps and actions that can be taken under independent administration, but by far and away, the primary benefit that is used is to sell real property. In order to understand how that works, we must first understand what the normal process is. In probate, when a piece of real property is going to be sold, the personal representative, which is the term I'll use, in the probate court, there are terms of executor, administrator, special administrator. Personal representative is defined as the term that encompasses all those fiduciary roles. So for simplistic conversation, we will use the term personal representative. So the personal representative must ask the probate commissioner, must petition to confirm the details of the sale, providing the contract price and all other relevant information. At the hearing, the probate commissioner will ask if there are any other parties willing to offer more than the current contract price. And just to be clear, when there is a petition, that petition must be provided, a copy, and the information must be provided to all interested parties, including the heirs, so they know what is going on. So at the hearing, when the commissioner asks for any parties that may be willing to offer more, the courtroom essentially becomes a mini auction. Sometimes there are individuals who are willing to pay more, and sometimes there are not. This helps to ensure that the property is sold for the right price and that the estate is receiving the value that it should. Independent administration can skip the court confirmation process where the petition is not required to be brought to the probate commissioner. This is done for a variety of purposes. Sometimes the heirs all feel the price is fair. They're all getting along. They're all communicating. They're brothers, sisters. their siblings, their cousins, whatever it is, it's a close family member. They're all doing just fine. And they're not looking to squeeze every single possible penny out of a sale, and they just want to move forward in an efficient manner. In such a case, they may desire to just move forward on the terms that the personal representative has obtained. Or sometimes there's a specific buyer who may not even be the top dollar, but because of other non-monetary reasons, they want to sell the property. It's a close friend or family member, someone who has ties to the property. Maybe there were some expressions of desire that this person have the opportunity to buy the property. But for whatever reason, the family is good without a top dollar sales price. And so they don't care about having the court confirm it and ask for the overbid process. However, the important thing to understand is when there is an independent administration, the personal representative must give all the heirs and the beneficiaries notice regarding the details of the sale. So more or less the same details that would be presented in a petition to the court will be presented to the heirs in what we call a notice of proposed action. This notice of proposed action must be given to all the heirs, in which they will have a certain period of time to either consent or object to the proposed action. If they do not object, they're deemed to have consented, and so it's a negative consent situation. However, because of the notice of proposed action, the personal representative, even through independent administration, does not have the ability to force an action on the heirs that they disagree with. They can't ram it down and just unilaterally take action that may not benefit the estate. They have the right to object, and therefore, once the objection has been made, all power regarding independent administration for that particular issue is taken away and must be done under court oversight. With that, I'll go ahead and turn the time back over to Senator Scheibel, and I hope that provides a good overview regarding how independent administration works for the rest of this presentation.
Thank you. And there are two conceptual amendments proposed to the bill. One of them I proposed, which is titled as SB 404 Conceptual Amendment. There's also a conceptual amendment from the Probate and Trust section of the Nevada State Bar. That is a friendly amendment, and I would like now to allow Ms. Rafferty to present that amendment. You have both the larger packet on your desk, if you have it printed out, is the amendment itself. There's a shorter executive summary of the amendment as well.
Thank you, Senator Scheibel, and thank you, Vice Chair. Michelle Rafferty, appearing on behalf of the Probate and Trust Section, the Legislative Committee for the Nevada State Bar. Also in Las Vegas is my colleague, Jeff Lushak, who is a co-chair as well. We want to thank Senator Scheibel for considering the proposed amendment that the section has offered today. This is, for your information, a nonpartisan committee. The State Bar's Committee is a group of practitioners, lawyers in the community, both north and south, statewide. There's no limitation on who can join the committee, and it's welcome to the entire bar who wish to participate. We come together to review probate and trust section materials, planners, administrators, and litigators, so it addresses all different aspects of the very important area of trust and estates, which impact all of the citizens of Nevada, especially those with smaller, more simple estates that really have a huge concern relative to the cost of administration, as well as the time that it takes for them to be able to administer their estates and trusts. So our proposals are designed to focus on those areas and helping them, regardless of the value of the estate. It encompasses all areas. First, in Section 1 that we've proposed, there is no, in Nevada, a breach of fiduciary statute of limitation in our statute. This creates a lot of questions when there has been allegations of a fiduciary breach, And so what the proposal is to add a limitation in Section 1 to NRS 11.190 in this that would recognize that interested persons do have the ability to bring a breach claim and to indicate that the 2-year statute for non-fraudulent breaches would apply. There is a longer statute that would apply, of course, if there's any allegations of fraud. In addition, the proposal in our remaining sections of affect Chapter 12, the design here is to treat executors and administrators, which are both personal representatives of estate and trust, similarly. Currently, we have a few areas within the code that are identified in the amendment provisions where perhaps there was an error oversight in the prior legislation where an executor might be required, for example, to file an inventory of the estate assets, but the administrator is not. And so we would want both to be able to be covered by those provisions. In addition, we've noticed in Senator Scheibel's bill that we support the idea of addressing the priorities of who has the rights relative to independent administration, but also rights to be the administrator in an estate that does not have a will or an identified executor. Currently, we have a variety of priorities that are set forth in there. We have an old provision in there that doesn't treat the half-blood heirs the same as whole bloods. And so, for example, we would like to remove that and clean that up, making sure that heirs are treated similarly within the statute. The additional item that we noted in a number of the sections, and I'm happy to go through any of them for you specifically, but in the interest of time, there are small estate provisions that we allow for smaller estates that are under 300,000, for example, to have a truncated process to move that through the probate instead of having to go through the long probate process. We like to increase those dollar amounts because of the cost of inflation for those particular families, proposing that, for example, the summary administration at 300,000 would be increased to 500,000. That the set-aside proceedings where they don't have to go through a formal probate administration and only have one hearing, that those would be increased from 100,000 to up to $150,000 estates. And then also for surviving spouses, they have the ability to file an affidavit in those cases rather than go through probate, and that would also be increased from the current 100,000 up to 150,000. In addition, the proposal also addresses a number of areas specifically that affect Chapter 13, and Chapter 13 is what covers the trusts. Trusts and estates, many of the provisions overlap because of the notice provisions that are set forth in Chapter 12 but apply to Chapter 13. The first one we've proposed for amendment here would affect the right of a fiduciary to reimburse the grantor for income taxes that are paid by the grantor on behalf of the trust. This is already in our statute, but it specifically currently requires that the instrument, the trust instrument, for example, grant that authority. Across the nation, the trend has been to have the default rule, but that the trustee has the ability to do that and only does not if, for some reason, the instrument prohibited that. In addition, there is an amendment that we've proposed in our Section 22. This would clarify the documentation that beneficiaries are entitled to receive in the event of a death so that their time to contest the instruments is very clear. Currently, it's 120 days, and we would keep the 120 days, but it's just clarifying when somebody amends their trust and estate, the time frame of the instruments that would have to be given to those individuals so that they know how to assert their rights if they choose to. Section 23 of our section, this addresses what we all see right now is the amount of trusts that are being brought to the state of Nevada that are from outside the estate. There's some lack of clarity as to when Nevada law would apply as opposed to the laws of another jurisdiction. And we would like to clarify the administration of trusts being administered here in Nevada would be governed by Nevada's administrative law unless the trust specifically prohibits that. That will give our court clarity as well as the beneficiaries and the trustee. And then lastly, on section 24, we've proposed, just to clarify, that once a trustee gives an accounting and runs the time frame, which is currently 90 days for objections, that the trustee would be released of further liability to further account unless there's, of course, an objection that is made to that. And I think that covers, unless there's any questions, I'm happy certainly to answer.
And thank you for that presentation, walking us through that amendment. And the document was prepared pretty well. I appreciate how you broke down the intent of each section. Members, any questions? Senator Ellison, please.
Thank you, Madam. I'm really happy that you raised that from 250 or 300,000. I didn't know it went up to 300. I thought it was 250, and it went to 500,000. I get that calls all the time. But I did have it said breach claims. How long has that been in the existing law right now? You had breach claims in, because the reason I asked that is, you know, somebody could go in later on and add that to the books or whatever. But the breach, you said there was breaches out there right now. Maybe I misunderstood that. But I think the breaches were important if somebody's out there trying to come in or take over. Now, I believe in living trusts, and I got all our LLCs into living trusts.
And Senator Ellison, I am getting word that folk following along are having a hard time hearing you. If I could just please.
I'm sorry.
Thank you.
Get so used to this mic being over here. But the living trust, that doesn't seem like that's changing at all, is it?
Michelle Rafferty for the record. Senator, thank you for your question. Is the question the breach of trust? We currently don't have a statute of limitation that even addresses the time to bring a claim for breach. And so that's what this is proposing to address, so that we make sure that becomes clear that there is a time frame to bring your action and within that action. Now, that's just for ordinary breach. Of course, if there's any fraud or gross negligence, anything that goes beyond the ordinary breach, it's going to fall under the fraud statutes, which are longer. But for ordinary breach, there just currently is no statute of limitations for a breach of fiduciary duty. Michelle Rafferty for the record. Senator Ellison, thank you. This would only affect trusts, because the breach of fiduciary duty on a trust would cover that. In an estate proceeding, the same thing, that would cover those estate proceedings. So this is for any sort of breach of fiduciary duty. It would add a specific provision recognizing the applicable statute of limitation. Again, this has been a source of a lot of litigation because there isn't any guidance right now, and so courts are left to interpret whether to apply a negligence standard, whether to apply a fraud standard, what statute of limitations would be applicable. And so this will clarify what the time frame is and eliminate that question.
And thank you, Madam Chair, for allowing that to be brought into this bill, because that clarifies a lot of information that I need to know when I get these calls, or personal. Thank you.
Members, any additional questions? Seeing none, Madam Chair, thank you for the presentation. I'd like to invite you both to sit back, and at this time we'll invite those wishing to testify in support of Senate Bill 404 in Carson City or Las Vegas to please come forward. I do see a gentleman in Las Vegas. Good afternoon. Are you here in support of Senate Bill 404?
I am, yes. I am the co-chair, Jeff Luschek, of the Probate and Trust Section Committee, which Ms. Rafferty, my co-chair, advised earlier that I was also participating in Clark County. So nothing to say other than I support everything that Ms. Rafferty said and our proposed bill.
Thank you for joining us. Is there anybody else in Las Vegas wishing to testify in support of Senate Bill 404? Seeing none in Carson City or Las Vegas, BPS, can we go to the phone lines, please? Support for Senate Bill 404.
Thank you, Vice Chair. The public lines are open and working, but there are no callers to provide support testimony at this time.
Thank you. Anyone wishing to testify in opposition to Senate Bill 404, Carson City or Las Vegas? Seeing none, BPS, can we please go to the phone lines for opposition for Senate Bill 404?
Thank you, Vice Chair. There are no callers to provide opposition testimony at this time.
And we'll stay on the phone line. Is there anybody wishing to testify in the neutral position for Senate Bill 404?
There are no callers to provide neutral testimony at this time.
Thank you. Anybody wishing to testify in the neutral position, Carson City or Las Vegas? Seeing none, Madam Chair, any closing remarks? And with that, thank you again for joining us. We'll close out the hearing on Senate Bill 404. The last item on our agenda is public comment.
Thank you again, Vice Chair Flores. I don't see anybody coming forward to give public comment in person in Carson City or Las Vegas, so we'll go to the phones, please, for public comment.
Thank you, Chair. The public lines are open and working. However, there are no callers to provide public comment at this time.
All right, then that brings us to the end of our meeting for today. We are meeting again tomorrow. Thank you again for bearing with us as our agendas are a little bit more flexible this week with the deadline coming up, but we will be meeting same time, same place tomorrow. Keep an eye on the agenda for the bills. Thanks. We are adjourned.